So I'm going to try and make this video accessible for people who are actually homeless themselves and need to complain about their own situation, and for those professionals out there who are willing to stick their head above the parapet and take a counsel on. Now, just to explain where I'm coming from with all this stuff, I worked in Bedford in an organisation called Just Us for, I guess, nearly 10 years. And in that time working for Just Us, I don't know how many complaints I made to various councils, obviously mostly Bedford Borough Council. And in Bedford, we actually saw something like 4,000% increase in the number of single people in TA. And it's been publicly acknowledged in one of the housing committees this year that it was on the back of the complaints we made that we saw those improvements. So complaining not only gets individuals housed, it gets compensation for individuals and a few other improvements as well, but it also can be used to get systemic improvements in the sector if you're willing to persevere with it and just push through some resistance that you will get. So I'm going to try and set out this as logically as I can think of. I'm not sure how well I'm going to do with that, but basically before you even put pen to paper or even start typing any emails to make a complaint, there's some research that you really want to get your head round just to set yourself up, set some good foundations for moving forward. So the very first question you want to ask is, what is the council's complaints policy? And the reason you need to know that, there's really two things you need to know. One is the timings, the time limits that you've got to receive responses to your complaints, but crucially how many stages there are in that council's complaint process before you can take it to the local government and social care ombudsman, which I'm going to call the LGO throughout this video because I'm old school, that's what it used to be called. The LGO is simply the independent organisation that's job is to hold councils to account, investigate complaints and issue recommendations, things like compensation, training for staff, those kind of things. So it's not a court process as such, it sits outside of that. It's something like Ofsted or CQC but for councils, and their remit is quite particular, which I'll explain a little bit later. But basically that is what you want to know before you start. How many stages are there in the council's complaint process before you get to that LGO stage? Because the LGO, in my experience, will be pretty good. You know, they're not always going to find in your favour, but I would say in my experience they're generally really fair, they're thorough, and ultimately you don't need to know the ins and outs of the law to get a good outcome. That's their job. You know, if you raise some complaints with them, they'll investigate themselves and they'll apply the law to the case and essentially work out what the situation was, whether there are failings, whether the council does need to improve, whether there is compensation available for you and so on. And one thing I'll probably reiterate later in the video is the first stage complaint response, or in fact anything except the last stage complaint response, because some councils have 3 stages, is likely to be a load of nonsense which is just going to make you angrier than you were already. And I'll give some examples at the end of the video of how I've seen that in Bedford. I've only ever seen one complaint ever which was upheld on the first stage, and that was Northampton Borough Council, doesn't exist anymore, where they told a victim of domestic abuse to go back to Bedford rather than accept the application in Northampton and house her in Northampton. And I think actually what happened is, it's almost funny, but it's not. I think the council drafted up 2 responses to the complaint. One upheld it and said, yep, we had a duty to act and we didn't. You know, we'll put training and all that sort of stuff in place to make sure it never happens again. And the other one would have been just kind of the usual obfuscating, just kind of gaslighting type stuff. And effectively, I think what actually happened was they sentenced the wrong complaint version. So we actually got it upheld first stage, compensation for her, and a good outcome. But that's the only other time I've seen it, because my guess is, and I'm speculating here, is that councils, their best line of attack or their best line of defence against a good complaint is just delay it, push it into the long grass, hope that you don't pursue it, and so just kind of basically put you off. So that's often what you get in that first stage. And again, I'll give an example of that at the end of the video of a case I worked in, where it can get actually really quite nasty sometimes, to be honest. So that's what you need to be prepared of. So essentially, that last stage complaint, whether it's 2 or 3 stages, it will depend on the council, but that final stage complaint is the one where you're going to get the most reasonable response from the council. And the first complaint I ever ran was upheld, actually, so that's probably not the best example. The second complaint I ever pursued for someone, the first stage wasn't upheld. I mean, this is very clear unlawful practice. The second stage wasn't upheld. We then wrote to the LGO, complained to the LGO. The LGO contacted the Bedford Borough Council, who immediately folded and said, yeah, no, hands up, fair enough, we did make a mistake after all. Now, they would have known that at the first stage. It wasn't legally difficult, but they basically just hoped that we'd go away if they're going to keep pushing back. And so this is one of the difficulties you've got if you are just a lay person, you're homeless yourself, you've got things to complain about yourself. in that it's your first time with them, the council will assume that you're likely to give up, and that you're likely to get befuzzled by all the technical bits of the law. And so both of those things you need to deal with in different ways, which is, as I say, what we're going to try and cover in this video. So you found out how many complaint stages there are in the actual policy, and you've also found out what the time scale is. So often councils will have something like 10 days or 20 days, working days that is, to respond to each stage. They will often go past those limits because, again, the council, one of the ways they deal with things is just hope it goes away if they don't do anything at all, it seems. So you will have to also potentially complain that the complaint hasn't been dealt with in the time limit. Again, we'll come back to that later. So you've got your head around the complaints process, the policy, and it will probably, or it may well get you to do it on the online form. And I would always avoid doing that. So I'll say at this point, actually, the first bit of advice I ever got from the local government ombudsman when making a complaint is ignore the complaint process. This was on the phone. It was advice from from an LGO kind of advisor who probably shouldn't have said this, but basically they said forget the ordinary complaint process. Which email address to send it to. Send it to the chief exec, and that is really good advice. That's probably the best way you can ensure that you get a good response, is to actually send it to the CEO of the council. That doesn't mean to say the CEO will ever read it, but the fact that the CEO is aware, someone in their office, their PA or whoever, will actually probably put some pressure on the housing department to actually look into it properly, or a bit more pressure anyway. It's not going to be foolproof. So you found. So the next thing you want to do is do some research on a council's website, and you want to first of all find out which councillors apply to you in your area, in the setting that you're in the scenario that you're in. So I'm going to use Bedford as an example, partly because it's a pretty typical website, also because it doesn't actually function properly, which is not unusual either with council websites. So if you go onto the local democracy portal, you should be able to put in your postcode, whatever that would be. If you're rough sleeping, just put the postcode of the area you're in right now, where you're actually rough sleeping, and you will get the councillor or councillors, often it's more than one, who cover that ward. So ward is basically a sub-district of the district, so they're called ward councillors. And you'll be able to get their email address, often their phone number. You'll be able to see which political party they come from, which is less important. In kind of local politics, I find that political party allegiance has less to do with it than MPs. So you'll be well able to find a Tory councillor who's decent, and you'll be well able to find a Labour councillor who doesn't care at all about homelessness. That's just the way it is, really. So that's kind of something less so to focus on, really. But you want to contact them. So you basically email them and say, look, I'm in your ward, I'm in your district, I'm a constituent of yours, and I'm currently homeless, or I'm currently about to be homeless, or whatever. I've approached the council, and for whatever reason they haven't done what I think they should have done. So you're basically first of all outline the complaint to the councillor. Hopefully that will lead on to a conversation where you can explain more about the situation to them. You can, if you want to, involve the MP as well, which again covers your constituency. Again, you can kind of go online and find out who your local MP is, and again find the MP's email address or whatever. But by definition, MPs have less authority over councils, or much less authority, if any, over councils than councillors do. So MPs can lean on councils and put pressure on them to do something, but there's no formal mechanism, as far as I know, to actually get them to do something. Whereas councillors, part of the reason they're there is to hold the council to account, to make sure it's actually doing what it should do. And when I worked at Bedford Borough Council, certainly when a question came in from a councillor, there would be a bit of a panic. We've got this question, how are we going to deal with it? And just to say at this point as well, in case I don't later, one of the things I whistle blew about Bedford Borough Council was that senior council officers would falsify evidence, which we're going to see a little bit later on when you're requesting your records. It's something to be aware of. You can't always kind of safeguard yourself against that completely, but it does happen. That's the reality. That's why I kind of do these videos, is because the system's not working, and there are some proper wrong uns sometimes in these senior positions within councils who knowingly break the law. So that's kind of what you're up against. So just to labour this point, you're going into this complaint situation with a massive power imbalance. The council essentially has loads of power anyway, but they're the ones who are used to dealing with complaints. They're the ones who actually know what the law is. You are coming in presumably fresh-faced, you've never done it before, or you probably haven't done it many times before. You probably won't understand the ins and outs of the law. So that's one of the weapons the council also will use, to try and kind of befuzzle you with all the kind of sections and stuff like that, and try and confuse you. So that's what you're going into. And again, if you've watched the video on the channel, the best way to make a homeless application, one of the reasons why I say to make a homeless application via email rather than ever speaking to anyone on the phone or going in person is that you then have a written record of what's happened. And actually a lot of complaints will kind of arise from those initial duties that councils have. So when you first contact the council, it's often the fact the council hasn't done what they said they should do. That can be the source of a lot of problems, basically. So find out who your local councillors are, go and meet them if you can, go and meet your MP if you can, there's no reason not to, there's nothing to lose particularly, and explain the situation to them. One of the things they can do at that point is if you've got a competent counsellor, they can actually go and resolve it for you there and then sometimes. You know, it doesn't actually require you to go down the complaints process any further, potentially, not all the time, because if the counsellor understands the law, then they would, you know, and sometimes they do because you've got lawyers, you've got kind of advisors and stuff in those kind of roles anyway. They can sometimes get some really good outcomes with minimal effort. So definitely involve them anyway, and we'll come back to using them again later. As well as the ward counsellor, there's some other key counsellors that you might want to get involved with. And again, Bedford's a good example of a website that's not really functioning entirely properly, because if you go into the committee section of the website, as we see here, we've got a number of scrutiny committees here, and we've got some other committees as well. But you'll notice that as far as I can see, the housing committee is not mentioned at all. But there is one, and there is a chair of the housing committee, and the chair of the housing committee is a counsellor in Bedford at the moment. It happens to be a very capable lawyer, which is really good. So you want to contact them as well. And if you've got children involved, contact Children's Services Counsellor. Some councils have a domestic abuse portfolio. So portfolio is just another fancy word for the department. So, you know, there's a portfolio holder for housing, would be the chair of the housing committee and so on. Sometimes the housing committee won't be called the housing committee. Sometimes you need to read the small print because it might be that the housing department is covered by the community scrutiny committee or something like that. So sometimes you've got to dig around for it a little bit. But there'll be a list of the councillors who are in that committee. If you really want to belt and brace it, there's nothing to lose by contacting all of them potentially, because they've all got an interest in housing and homelessness and how the council's discharging its housing duties. So those are the ones you want to involve. And you know, wherever possible, this is stuff you've done before you actually started a complaint process. Now, on that point, when you're kind of doing this groundwork, when you're figuring out what it is you need to do, one of the big questions you've got is, can my complaint wait? Sometimes it can't. Sometimes you're homeless tonight and you need to complain right now, for sure. When I worked at Just Us, we would, wherever possible, wait until the person was housed before we would then complain. And the reason for that was partly because when I worked for Bedford Borough Council, one of the things I witnessed there was where someone was, you know, complaining and causing a bit of noise, the housing officers weren't in any way decent about that. And essentially what they kind of end up doing sometimes is begrudgingly to say, well, we've got to follow the law. We've actually got to house this person because, you know, the councillors are involved and whoever else. But what they then do is they basically give the worst possible service they could do. So they kind of essentially find a hard to let property, which is a code for just total shithole that no one wants to live in, and basically give them a direct let and, you know, say that's it, take it or leave it. So there certainly seemed in my time at Bedford, and I'm sure there is in other councils as well, this kind of retaliatory attitude, you know, so where someone raises a robust complaint and makes their lives a little bit unpleasant for them, they will retaliate by giving you rubbish service in a way that's legal, but it's also the kind of the worst service they can possibly get away with. So that's why at Just Us we just wait. You know, we wait until the person was housed, if at all possible, and then kind of go from there. So that's something you need to work out. The difference, this is probably a good time to mention it. You've got two avenues, or at least two avenues, to challenge council homelessness activities. If you're challenging the actual decision, so let's say the council says you're not in priority needs, but you've got a list of medications, list of medical conditions as long as your arm, and it's very clear that you're vulnerable, you can complain about that. But often what happens is if you complain about it, they'll deal with it as if it's a Section 202 review request. So Section 202 is just a bit of the Housing Act, which explains how people can challenge those decisions. So that's ordinarily how it would deal with it. So when you get the non-priority decision, it will say at the bottom of the letter, if you're not happy with this decision, you need to write to this person here within 21 days of receiving the letter so that you can basically get that decision looked at again. Now that's different from a complaint. Now ultimately, if you go down that avenue, and let's say the review is unsuccessful as well, but you know you're right, you are vulnerable, you are in priority needs, the next step after that would be to go to court, and you'll basically need a lawyer at that point for sure. Ideally you want a lawyer at the Section 202 stage as well, to be honest, but very difficult to get, so you can get by on the Section 202 without a lawyer. Section 204, that appeal process to the courts, is very different from that. You need to have a lawyer really to do it. Technically you don't, but you do. And so you would challenge that decision. So that's outside of the complaint kind of remit, and if you complained about that and went all the way to the local government ombudsman, they would simply say, you know, you had a right to go down the court process, you didn't exercise it, there's nothing we can do. However, there will be some times when in amongst that perverse non-priority decision, or that perverse decision of any kind, there will be failures which the LGO can look at. And I'll give an example. Actually, the LGO didn't get involved in this one in the end. It was dealt with at complaint stage. But a few years ago, I worked with a guy. He had a heart attack and he was alcohol dependent. He made a homeless application. Well, I helped him make a homeless application basically on the basis of evidence I was able to get from the local drug and alcohol service, which was that he was at high risk of relapse because he's now abstinent, which is, you know, ties in specifically with homelessness case law, which is why I raised that kind of line of thought. And the council responded with probably a same day non-priority decision. I can't remember. It was certainly a non-priority decision anyway. And in that non-priority decision, the senior housing options officer said that alcohol use is always a lifestyle choice. It's got nothing to do with the decision about vulnerabilities. Or words to that effect, basically. It said, you know, it's always a lifestyle choice. That's the bit I cottoned onto. So I challenged that non-priority decision through the Section 202 process, got it overturned. Happy days, guys housed. But I also complained about the fact that a housing officer is saying that kind of stuff in a decision, in a legal decision, basically, because it's a free country. You can believe what you want about substance use being a lifestyle choice or not. But in the sector, in the professionalised sector, you cannot ignore medical evidence. That's not okay. You cannot ignore the weight of, kind of research behind trauma and stuff. So trauma is becoming increasingly understood now. And so there's a whole raft of things which would preclude a housing officer from saying those kind of things. In a similar way, I'm going off on a bit of a tangent. When I worked at Bedford Borough Council, I remember one occasion where a senior housing options officer gatekept someone specifically because of their race, nothing else. They didn't even know the person's name, they just knew what race they were, and they basically just denied them housing. And so, you know, in the same way, you know, there are plenty of racists out there for sure, but if you're going to come and be a housing officer, you need to put those beliefs to one side and actually apply the correct test to your case. And if you don't do that, and in the case of this lifestyle choice example, for me, I just couldn't have a senior housing options officer putting that kind of stuff out there, because I'd imagine that sort of mindset infected lots of other things they did, and it's just not legal. You know, the case law on substance use is very clear. The Code of Guidance mentions it quite a lot. The case law is pretty good, and again, it's much more progressive than the Victorian type moral test that a lot of housing officers seem to kind of apply. So not only did I get the non-priority decision overturned and get the guy housed, but the complaint seemed to be very effective in the sense that since then, Bedford Borough Council's housing team, as far as I know, has not advanced that kind of argument in writing. Now, I'm sure they still believe that, some of them, but it did kind of put a little bit of a damper on that in terms of them trying to do that sort of thing again. So that's a good example of where complaining can lead to a systemic change as well as an individual, as well as kind of getting the individual housed through the Section 202 process. So I'm hoping I haven't gone too much detail there, but yes, you need to work out your issue with the council. Is it something that needs to be dealt with through the Section 202 process because the decision's wrong, or is it that there's something else about it? You know, the fact that gatekeeping is a big issue here. So let's say, for example, you're rough sleeping. You go to a council saying, rough sleeping, can you help me out? You trigger a homeless application, and they say, well, there's nothing we can do until you get verified by the rough sleeper outreach team. That's pretty common. That would also be something that the LGSCO, the LGO, would kind of take care of, because that's just kind of that process not being followed properly. Another thing that's probably worth saying as well is that complaints about things that are not in writing and in the written records are quite difficult to get upheld. So, for example, it's very common for housing officers to be very rude and kind of very bullying in their behaviour and very oppressive. But it's quite difficult to really get that kind of complaint upheld, because you make the complaints officer deals with it, they go and talk to the housing officer, and the housing officer says, oh no, I wasn't rude, it was the homeless person being rude, not me. And effectively, the complaints officer will always side with what the housing officer says, or nearly always side. I'm sure there's some exceptions, but it's very rare for that to happen. The only time I've ever got the LGO to uphold a complaint about something that was verbal was a Northamptonshire case where the lady was told that if she didn't accept accommodation, her child would be removed from her care. Now, that obviously wasn't in writing, that was said verbally. But the reason we got it upheld was, as soon as she told me, I immediately complained, I immediately raised it. When I went to the LGO, I not only kind of showed that I raised it contemporaneously, which means at the time, but I also did a bit of Googling, and I found that Shelter had actually campaigned on this issue a few years ago and basically said, look, on the balance of probabilities, it seems more likely than not that this housing officer did actually say that, rather than this homeless person just made it up on the spot without kind of any kind of bearings on reality. So, and it got upheld, so that was good outcome there. Even though the housing officer denied it, the LGO said, yeah, it probably happened. That's probably what happened. So there was kind of became an element of the compensation she then got. So, yeah, generally speaking, that's why it's quite difficult to complain about stuff. Now, a lot of the people I talk to, actually, the way they're dealt with by the housing officer is actually the worst thing about it all. So actually, it might not be the detail here about legal aspects to it. It's just about how they're dealt with, and there's a lot of stuff around that as well, around the council's default position to disbelieve you. That's something which comes up quite a lot. Those things can be incredibly difficult to deal with when you're already in a bad way, but quite difficult to raise as a complaint. I'll give you some examples of complaints of varying difficulties in kind of getting upheld. So probably the easiest complaint, or one of the easiest types of complaints, would be where a council houses a family with children in B&Bs for more than 6 weeks. And the reason it's so easy to get that upheld is because it's very easy to evidence when you were living in the B&B. It's very easy to evidence when the council's time limit ran out, that 6-week time limit. So, effectively, if you made a homeless application on the 1st of January, placed in a B&B with your kids, the 6-week limit would be whatever, the 10th of February or something. And then you can just evidence, let's say you're still in B&B in June, you can add up the number of weeks past that 6-week limit, and you can basically come out with a pretty straightforward complaint in terms of I've been in B&B for 16 weeks more than I should have, and that would then kind of correspond with an amount of compensation that you can then ask for, which I'll kind of deal with at the end. So that's a really straightforward complaint. There are other complaints which are more intricate, but still can be made successfully. But yeah, I'll run with those kind of examples just for now, just to try and illustrate this where I can, kind of how this can kind of proceed. Now, so let's say you've done the groundwork, you've researched the policies, you found out who the local councillors and the local politicians are. Another thing you can do is search for your council's name on the lgo.org.uk, LGSCO, but the website's still lgo.org.uk. So you can actually search for your council and see if there's any upheld complaints there already. And it's probably worth reading a number of complaints. Just have a little browse on that website, because you can get the idea of what sorts of evidential standards the LGO works to. And the LGO are so good at explaining what the law actually is, probably better than the Code of Guidance, definitely better than actually reading the law itself, because they introduce each case with what the relevant legislation is, and it's just really well set out. So highly recommend reading that. But it might be, you search for Bedford Borough Council and you can see on there that, they've had another case where they also did something similar to someone else, and you can kind of get an idea of how you can piece things together. Or if you really want to go deep into it, let's say the issue is you've been gatekept, you've been told to go rough sleep, you might be able to find a similar case on the LGO website and just kind of piece together, okay, what kind of information did they use to actually reach that decision, because you want to be able to try and get that same level of evidence as you go forward. So you've done all that groundwork. Next thing is to actually start working on your complaint. And again, before you put pen to paper or before you start writing that email, there's some really important things you want to do if you have the time to do so. The most important thing by a mile is making a subject access request to the council and potentially other organisations that are involved, because that can be helpful. So that SAR, that subject access request, that SAR process is your right to see any data that the organisation holds about you, with one or two exceptions, but they're very obscure. So, and again, if you just search for Bedford Borough Council subject access request, you'll get the online page and it will tell you how to do it. Again, you can just do it in writing in an email, to be honest, rather than actually using the online form. because online forms, as with a complaint process online form, you don't often get proof that you've actually sent it, and that can make it really difficult to then chase it. So I would always say always use emails. There might be an online form that does complaints or does subject access requests. I would just send an email, and if nothing else, you can look in the council's privacy notice, which is their policy on how they use your data, and at the bottom of that, or somewhere in there, there will be the data protection officer's contact detail, and quite often it will just literally be dpo@bedford.gov.uk or whatever. That would be an appropriate email address to send a SAR request to. So you do that. Often you might have to back it up with some photo ID or something to prove that you are who you say you are, which is fine. They've then got 30 calendar days to respond to that, unless it's exceptionally complex. I've only ever seen that once, so most cases it's not difficult at all. And in an ideal world where you're able to do this first before you make the complaint, you're at a bit of an advantage, because going back to the issue of councils falsifying records, it certainly does happen. I certainly witnessed it at Bedford. And what you almost kind of want to get the records before you make the complaint, because first of all, the subject access request is probably going to be dealt with by someone in the data protection team rather than the housing officer itself, although at some point they probably will bring them in, but your actual housing officer might not know it's happening, so they might not get time to go and change the records basically before you get those written records. Now, SARs are either given to you in an electronic format, often with like some sort of online secure kind of password or whatever, which can be a bit of faff, but it's doable, or they might just simply send the printout of it in a big document to you in a big envelope, and either way is fine. They're both legal. Personally, this is just personal preference, I always want to have paper copies of this stuff, because I want to read through them, highlight them, kind of put arrows and all that sort of stuff to make sense of it in my head. And either way, if you're going to get a printout, if you're going to get a paper version, a little tip is to number the pages before you do anything else with it, because you want to keep track of all the documents you've been sent. They'll often be sent in a random order, but sometimes there will be some kind of sense to it. So numbering the pages is a good way of you keeping track of it, not getting it all jiggled, mixed up and whatever, before you even start to look into it. So you've got the documents back. I've had to complain to a council before because they haven't actually responded to the request within the time frame, which can add further delays to it. So that's something to bear in mind. Something I haven't mentioned yet actually is that the LGO, there's a 12-month time limit on making a complaint from the point of when you actually became aware that there was a failure. So if you only just become aware of it, the clock starts ticking. You need to factor in the fact that you need to get through that complaints process within 12 months. So I said to you about kind of delaying it as long as you can. You can't delay it indefinitely because you need to be within that 12-month time limit. The LGO will be reasonable with that. So if you haven't got to them within that 12-month period because the council's delayed in responding to the complaints, obviously they're not going to hold that against you. But you need to have almost worked out in your calendar. You look to the complaint policy. There's a 10 working day response time for the first stage. There's a 20 working day for the second stage. You need to work out what's the date you need to start that process off. Otherwise you might miss the deadline altogether. So you've got the SAR, you've numbered the pages. There often will be within that SAR document loads and loads of emails, documents, random stuff, risk assessments, all that kind of thing, but somewhere there'll often be a chronology already built into it. So there'll be like an IT record system or something, and it will basically have an index of all the different interventions that were recorded about. There'll still be stuff missing about it, but that's fine. That can often be a really good point, a good starting point to start your chronology, because again, before you're actually writing any complaint down, and this takes hours, but it's worth it, you want to write a sequence of events of what happened when. So 1st of January I approached the council. 1st of January council placed me in B&B. 14th of January or 14th of February council didn't remove me from B&B, so I'm still there, got kids or whatever. And 24th of June council still housed me in B&B. So that would then give you that kind of time frame. There's often lots of other things happening at the same time. And what can often become apparent as you do that is that there's actually missing documents from the SAR response. You might also know that there's missing documents because you yourself sent them emails which are not recorded in that those documents you get back. Bearing in mind, you can ask for everything about you. That includes emails about you, registers, whatever else it might be. That all needs to be provided to you. And Again, I don't think it's actually that cynical to say, often the documents you need, the most crucial documents will be the ones they don't send you the first time. I've certainly had that a few times where I've had to really kind of doggedly go after the council and say, you have this document, you need to provide that as well, because that's then the key document which explains or kind of, you know, exposes the issue in the best way. So you do this chronology, and then you start drafting up your complaint, and your complaint should really only be maximum really a side of A4, and that includes the kind of, you know, the gubbins, you know, dear council, you know, all that kind of stuff as well. And you want to number your points, and I'm going to go through, I'm going to share my screen at the end of this video and explain, just give an example of this, of how this kind of often progresses, because your numbered points just mean that it's, first of all, easier to follow, because, you know, often situations are quite difficult and you're expecting a council officer who probably doesn't have a lot of time to understand your situation. So you want to number your points, and it might be simply, you know, point number 1, housing officer was rude to me. Point number 2, council housed me in B&B for more than 6 weeks, and so on. So you've got these kind of numbered sections which you can then trace, because the first stage complaint goes in, the first stage response will probably correspond to those numbers. You then can take it to the second stage, you can add numbers into that stage if there's things which are kind of missed out or whatever, but it just becomes much easier to track. And the same thing with a chronology. A chronology enables you to communicate to other people what happened to you. You know, for you it's very apparent what happened, but when you try to go to a counsellor or try to communicate with a counsellor to explain what happened to you, a chronology is a great tool for you to explain, okay, this is the sequence of events, here are the failures. You can maybe bring in bits of the law at that point, the code of guidance or whatever, to kind of back it up. I'll talk more about that as well in a little bit. But that's something you can do. That chronology becomes that kind of cornerstone of this drafted complaint. So you've numbered the complaint, you go through, as much as possible, you don't want to kind of get into the detail too much. It's enough to say, the council housed me in a B&B for more than 6 weeks and I've got kids. That's kind of enough to say. You don't need to kind of go into which housing officers are involved necessarily. It doesn't really help you. Now, if you have a trusted friend or trusted family member who is known to be kind of, you know, quite sober-minded and kind of, you know, thoughtful and wise or whatever, send it their way and ask them if they're happy for them to read through it, just to see what their thoughts are, because ultimately they can then say, well, look, you know, I know this makes sense to you, but this bit here does make sense to me, and then you can kind of vary it accordingly to make sure it's actually saying what it needs to say. So you send it off via email to the chief exec, copying in the local councillors, and then you just kind of wait. Basically, you wait for that time limit. So let's say it's 10 working days. You'll then get a response. If you don't, you go back to the chief exec and say, I made a complaint on the 1st of January, it's now the 11th of January, I've not had a response back yet. Your policy, you know, you can quote the policy, your policy says it will be done within 10 working days or whatever. So you get that first stage response back, and this is often the most horrible part of this process, because the first, and I'll give an example of this at the end, the first stage complaint response will basically try and gaslight you. It will often have incorrect, misleading information in there. It will try and say that you did things that you actually didn't do at all. It will basically do anything it can to avoid taking responsibility. That's how the council, that's often seems to be how councils operate within the complaints process. First stage is just basically deny everything you can, or like only admit certain things which don't really matter, and deny the crucial bits of it. Not all councils, I mean, you know, there are some councils that may be a bit different from that, but most councils, that's how I've seen them deal with these things. So you just need to kind of take a breath and just, rather than kind of getting drawn into these different arguments, you need to go back to your bullet points. You know, did they actually say anything in what they said which actually contradicts what you said in the bullet points? So if you said, the council's kept me in a B&B, you know, for 6 months over that 6-week limit, and actually the council's records show that actually no, you were moved to a suitable accommodation in March rather than June or whatever, then that's a problem for your complaint. You need to go back and work out why it is you thought that you were still in a B&B. I mean, obviously that's a rather silly example, but there might be some times when the council does respond, you know, sensibly and politely, and actually says, do you know what, actually, yeah, here's what the law actually says about this, or here's actually what we understood, this is what we knew at the time. Because there will be, you know, in amongst all this, there will be just genuine misunderstandings and and kind of incorrect things that happen. That there's no malice involved, but a lot of it, you know, in my opinion, there will be a lot of malice involved sometimes, to be honest. So your second stage complaint, you just basically, I've done second stage complaints which are basically the same as the first stage complaint, just changing the dates, because the first stage complaint from the council didn't actually address any of the points really in any substance. So you're just making those same points again. Again, send it off, Chief Exec. You can be very polite about it, say, thank you, Chief Exec, for taking the time to deal with this issue. Copying the councillors. It might be that you want to have a conversation with the councillors if there are things which you think that they just need to know. And you just let it roll on. So let's say the second stage complaint window is 20 working days, so that's basically a month. A month later you get the second stage response. I say second stage, some councils have a 3-stage process, but that final stage is the most likely to be reasonable. So yeah, as I say, the first time, the second time I made a complaint to Bedford, they didn't even uphold at the final stage. They only upheld when we went to the LGO. But most councils I've dealt with, they will actually give a sensible kind of response at that point. Now, it might not give as much compensation as you think you're owed. It might still not do things, but what they really want to do is try and appease you and stop you going from the local government ombudsman. In that second complaint I made, I kind of mentioned that it went to the LGO. The council folded at that point, so before the LGO even investigated it, the council came back and said, no, fair enough, we'll make an offer. So they offered something like £800, and actually that was more than the LGO would have recommended in normal circumstances. And we went back to the individual, talked about it with him, and he said, look, I don't really care about the money, I want the council to be investigated and I want the LGO to recommend kind of improvements for the council to take. So he went back to the LGO at this point and made that point, said this is what the individual wants. And the LGO basically said, you know what, because the council's offered more now than they would ordinarily be recommended to pay, we're not going to get involved any further. And that's fine, because what that meant was the LGO then published the decision on their website. And so you've got to remember that the councils not only care about the money they have to pay in compensation, they're probably more bothered about the negative press they might get if the complaint gets through to the LGO. Because we said elsewhere, or said it quite a lot really, it's actually cheaper for the council to get caught and pay the compensation than it is to house the person in the first place. So really that risk of exposure in the press or risk of public exposure to the council is one of the biggest bits of leverage you've got. That's the thing they're probably more scared about rather than just the money. So you can use the LGO in that way to to basically make sure that the council actually kind of improves things and does things properly. Another example with that was Shepway Council, which doesn't exist anymore, down on the south coast, where again in one of my early complaints, victim of domestic abuse, told to go back to Bedford, told she had no local connection. And again, they offered something like £150 at the second stage, which was way less than what they should have. So again, took it to the LGO, and the LGO recommended a suitable amount of compensation. I can't remember how much it was, like 600 or something. And also the LGO recommended that the whole team in the council had to go on homelessness law training. So that was a really stupid example, or an example of a really stupid second stage response from Shepway Council, because if only they'd offered the right amount of money the first time, they might not have had that additional stuff going out into the public domain of the fact that they failed and they had to do training. So you can kind of see how this can get quite interesting if you're trying to get an area to improve its services systemically, because you can use these LGO decisions to expose particular issues within a council. So you've got the second stage complaint response back. Unless you are completely happy with it, take it to the LGO at that point. And again, if you go on the LGO's website, there's like an online form thing, and this time just use it because it's fine. If you're doing it on someone's behalf, you need to get them to sign it, obviously, just to say that they're happy for you to kind of make the complaint on their behalf and so on. And then you just have to kind of wait a bit longer. So it's not unusual for a complaint to take 18 months from start to finish, because you've got to mess around with the council delaying. You've then got to go to the LGO. There's often a backlog. So last time I did it, it was maybe a 3-month or so backlog before they started to look into it. And you've got something like between 3 and 6 months probably at the LGO whilst they investigate, because they'll be corresponding with the council, getting additional records, coming back to you asking for more records, going back to the council and so on, before they're at that stage of making that final decision. But that's kind of how it tends to work out. And as I say, if your complaint is sound, if you've actually got a good point, then the LGO is likely to uphold it. The downside of this is obviously that it's not going to sort your problem out now. So if you're homeless tonight, the LGO is not a lot of comfort to you unless you can convince the council that you have a robust complaint and you are going to take it to the LGO, which is again is why you want to bring in those counsellors at that earlier stage, because they can actually have that sensible conversation with them. Because essentially no one wants to have egg on their face. You know, if everyone knows about it, if the chief exec, if the MP, if the councillors all know about this situation, and then it doesn't get resolved immediately or very soon, and then the LGO upholds it 18 months down the line, everyone looks bad, and politicians don't like looking bad, so that's something that you can kind of bear in mind as well. A few other bits and pieces, you might want to quote the law in your complaint. So let's use that 6-week B&B stay or overstay. You might just want to quote the bits of the code of guidance which say councils can't do it, and then you might want to quote the bit from the local government ombudsman guidance and remedies which says £100 to £200 per week over the limit, just as a pretty sensible, you know, kind of way of arguing your case. But you don't have to say more than that. You don't have to kind of over egg it particularly. Just make those kind of references to it. As much as you can, keep the emotion out of it, you know. And there's no point kind of, I've seen some people sometimes complain, say, oh, you know, everyone's got a human right to housing, and they don't. There is no human right to housing. You know, I wish there was, but there isn't one. So there's no point kind of going down that line. You want to focus in on the things the council did wrong according to their own policies, according to the law. That's the things that's going to get your complaint upheld. The last thing that's going to just tie up this complaint nice and neatly is going to be to look at the local government ombudsman's guidance on remedies. And if you basically find it online, it's easy to find, just Google it. And essentially it's a document which lays out the kinds of figures, the kinds of amounts of money you want to be asking for. So if we just go to it now, again, I'll just share my screen so you can see that. This is what it looks like. Basically got a bunch of subsections, and really the ones you want to be looking at most, you probably want to look at the introduction and part 2 as well. You've got part 3, which is the approach to remedies, which probably goes into a bit more detail here. And it talks about, you know, what is an effective apology, and it kind of, you know, says some really good stuff there in terms of how councils often try and make out like it's not their fault. So it's good stuff about there. And then if you go down to 3.7, you've got this section which is titled Make Symbolic Payments, and this is where you can start to do a bit of math to work out what kind of amount is going to be a reasonable amount to ask a council for in terms of compensation. So you've got these different components of what makes up the compensation. You've got distress, then you've got harm or the risk of harm, you've got time and trouble, and you've got non-direct injustice. Now there are other things which are not covered here. So for example, if you lose belongings because the council haven't discharged their duty to protect those belongings, then you would essentially ask for the amount that those belongings are worth. But these are kind of the general kind of things that you're going to see within complaints. So distress, most situations involving homelessness when you are unlawfully denied housing are automatically going to basically mean that there's some distress there, because that's the nature of homelessness, right? There's no reason why you would not be distressed if you were left homeless. You've then got this section harm or risk of harm, and that might be because you were a victim of domestic abuse and the council failed to act as they should have done, and you had to go back and then were subject to further abuse. So that'd be a kind of pretty serious one there. And again, there might be situations, for example, where you're told to go and rough sleep and you're attacked whilst rough sleeping or something like that. Again, these would be things which would be you know, not uncommon, sadly, that the LGO is going to be looking into. The time and trouble, that is really kind of certainly in part looking at how long does it take to actually get the complaint resolved. And I've never quite sort of seen any consistency from the LGO on this one, because any complaint you have to run through the whole complaints process and get to the LGO is going to take some significant time and trouble. But I've seen varying payments from that, but again, you want to add that in. We'll go a little bit further down in a minute just to see what sorts of amounts they're talking about. And then you've got this idea of outrage, which I'm not sure is particularly well defined here. You can read it for yourself obviously on the screen. I've certainly seen cases which any reasonable person would say were outrageous, and I've kind of added money onto that amount that we asked for because of it. So if we then go through the sections in a bit more detail, you've got distress, and again you can read this for yourselves in more detail. But crucially, let's just kind of go to the amounts here. So where we decide is it appropriate, we will normally recommend a remedy payment for distress of up to £500. So that's kind of a starting point there, up to 500. If you've got a particularly distressing situation, let's say for example it involves someone with, I don't know, a disability like autism, where by the nature of the condition they're going to be more distressed by kind of the same sorts of things that other people experience, then you may be looking at higher than that, but it's essentially unlikely to be more than that. You've then got harm and risk of harm, which is a symbolic payment of up to £1,000. Now I'm pretty sure I've got more than that for people, because the scale of the abuse they suffered because the council failed, and I'm thinking particularly of the Bedford case here, was just so extreme. So again, you know, you can go over that limit sometimes, but it's, you know, the typical one would be up to 1,000 obviously, and if you're actually harmed rather than being put at risk of harm, the actual harm would result in more money. You've got kind of, time trouble because of delays in complaint handling, which is not unusual these days. It seems, as I say, that councils basically deal with complaints partly by having an under-resourced complaint handling team. So, you know, obviously they kind of struggle to meet the deadlines and so on. And you've got the fact here, complainant had to ask a councillor or MP for help. There's one other bit I want to talk to you about. So that's the kind of generic bits that would apply to all the different remits that the LGO has. But then there is actually a section specific to housing, and in fact there's one specific to homelessness, although it does talk about B&Bs elsewhere as well. So if we go down to that, you again kind of got this idea of a payment of between £100 and £350 per month that you're left without suitable housing. And again, if you're left rough sleeping, that would be, you know, closer to the £350 mark, which in my mind is ridiculously low, but this is what we're working with here. So you've got this kind of amount there. And again, you know, you've got other things that might be taken into account here, and so on. So again, you can kind of check that out. You've got also this unsuitable bed and breakfast placements, which I've talked about already in this video. It's actually a very easy one to get compensation for. And here the LGO recommends between £100 and £200 per week that you're over that 6-week limit in B&B if you've got children or a pregnant woman living with you. Or in fact 16, 17-year-olds, it says there as well. So that's the kind of thing you really want to, again, just kind of take your time to read this stuff through. And if you can, as I say, I'll just show you the LGO section on the website that kind of has those decisions in as well, because again they're just really helpful. So if we go back to the home page here and then go to search for decisions, I'll just give an example here. So let's just search for Bedford Borough Council, and if we just go down, we've actually got Central Bedfordshire as well, because obviously the search is picking it up. And you can kind of see, you know, often these are kind of closed early on in the stages because effectively the complainant didn't really kind of do their homework. You know, they kind of ended up complaining about something that should have been dealt with the review process, or it just wasn't substantial enough. It might be they're complaining about things which, you know, just the council hadn't failed on. You know, the fact that someone might have to wait for several years to get housed, that doesn't necessarily mean the council hasn't followed the law. So you've got a lot of stuff there. We've seen Central Bedfordshire has a lot of action here, and you can kind of trawl through it. Another thing you can do is and just note that you've got all the different remits. So you've got planning applications, looked after children, antisocial behaviour. So there's a whole bunch of stuff which, you know, not going to be interesting to you if you're dealing with homelessness. What you can also do is basically go down to the browse decisions section again, go to housing, and that can help you just kind of kind of home in what you want. So you've got homelessness here. There might be other things that might be relevant here, and then you've just got a whole bunch of cases which I would highly recommend reading at least a handful, because they just give a really good understanding of how the council will look into it. So you've got London Borough of Ealing. So I'm recording this on the 10th of September 2024. So these are just kind of most recent ones that have been published. So you've got London Borough of Ealing. It was upheld. And essentially, so in fact, if we just have a little dive into this one, because it's worth just kind of seeing what sort of thing they do. They give the summary of the case first, which is, in this case, the finding was that fault was found causing injustice and recommendations made. Then he gives the recommendation. So she got £1,000 for certainly some of it. Might be some other stuff there. And the investigation section is even more interesting. So you've got what the LGO does, you've got the homelessness law and guidance, which can get incredibly interesting. If you're a professional, there are often answers within this section which you won't find anywhere else. So, for example, how Mental Health and Equality Act law interacts with homelessness law is fantastic. I don't know anywhere else that you can get this information. You've then got a bit about housing allocation. So that's essentially just setting out the kind of relevant rules here. Then they do a section of what actually happened, and I haven't read this before, but my guess is she was failed and gatekept and left at risk of domestic abuse, and had to reply several times by the look of it. I'm just literally just kind of scanning through now, and then you go back to the end. You've kind of got the breakdown of the remedies. So you've got £1,000 to recognise her significant and avoidable distress, uncertainty, and missed opportunities over a prolonged period. Now, I would say that's still quite a low amount, really, when you look at what this lady probably would have gone through. The fact the council's already got to make an effective apology, and I think there's also kind of scope there for the council to, I don't know, maybe kind of retroactively install her onto the housing register or something. Again, you can read all this yourself. But that's just one example of many. You know, and kind of go back to say you've got Calderdale Metropolitan Borough Council, which again was upheld. You've got West Oxfordshire Council upheld. I think overall, most complaints don't actually get upheld because of that kind of fundamental issue with the person raising it. They might be out of time, or they might just kind of raise the wrong issue. And you'll also notice, I've done separate videos about this, almost all of them are in London, basically. Because it's not because London Council is necessarily the worst offenders, it's because there are the most services there to support people to basically get compensation. So that's hopefully useful stuff around basically the local government ombudsman, just their guidance and remedies. They also do focus reports, which we haven't got into there, which again, just a really good way to understand the law and kind of how councils often fail. So you look at focus reports on things like gatekeeping, domestic abuse failures, how the Equality Act is considered, all those sorts of things could be really, really helpful. And then I'm going to finish this video by trying to give you an example of a case I was involved in quite early days for Just Us, when I was working for Just Us. And it's going to be helpful if I give quite a bit of context to this, because for me, I'd say there's quite a lot of different angles you can look at this complaint and how it all kind of worked out, and you know, the outcome from it, which might well be useful, not only if you're an individual who's homeless yourself and needed to complain, but probably more importantly, actually, if you are a professional trying to get those systemic improvements in your area. So just to give you a bit of background to this story, just to make sense of what was at stake here. I worked in Bedford Borough Council 2011 to 13. I whistle blew in 2013. And then I then set Just Us up with my friend John Allen, and we just basically help people from Bedford Borough to access the assistance they were owed under the council's duties. I've kind of mentioned a couple of complaints we've got, you know, kind of upheld already in this video, but as we'd been doing this a couple of years, we got more and more resistance from the council. And it probably didn't help that I was a whistleblower, and kind of, you know, essentially some of the people I was dealing with at the council, I'd, you know, kind of whistleblown on their bad behaviour. But basically, after a couple of years of doing this, we basically compiled a list of case summaries of the individuals we've been helping out, particularly around domestic abuse, because politically it was kind of harder to sweep under the carpet. And we'd submitted it, or we were about to submit it, when the events of what I'm about to say happened. So we're looking at sort of 2016, that sort of time. So it was already drafted up, the report was drafted up. There was maybe like 10 or so cases by this stage, and this became the 11th or 12th case that we then took into it. And this lady, obviously anonymised this, she had suffered extreme domestic abuse, and she had suffered a life-threatening internal injury, without going into more detail. Been to hospital. She'd actually self-discharged because of the anxiety that she was experiencing. Police had tried to prosecute the perpetrator without her kind of, you know, having to give a statement, but that kind of didn't work out. She'd then been sofa surfing and ended up rough sleeping in a graveyard by this stage. She'd gone to the day centre in Bedford, who had kind of told her to go into the council, I think. And that was a Monday. I remember it being a Monday. I never know exactly what happened there. She actually met with one of the more kind of decent housing officers there. However, I can see no way there where there weren't really kind of significant failures in that. And bearing in mind, at this point in time, Bedford were just simply refusing to take homeless applications a lot of the time. So you kind of see that as you happen on. So we're having to insist that those basic duties owed to people under Section 184 and Section 188 would actually be followed by the council. And they just didn't like it. They just weren't used to getting that sort of challenge. So on the Monday, she was just basically kind of told, you know, there's nothing we can do. Not quite sure how that happened, because in my experience of her, she was not in any way guarded or kind of secretive about what had happened to her. It might have been the fact that she was being interviewed in an open plan customer service centre, and, you know, expected to kind of divulge this very sensitive information out of the setting, which might have kind of, you know, prevented her from being open about that stuff. So nothing happened on the Monday. Tuesday we got a referral to Just Us, and I went into the council with her because I just wanted to get a roof over her head that night. Bearing in mind, you know, the kind of stuff I said about always doing it in an email, at this point I hadn't quite figured that out yet, so I'd kind of gone in there with her. Again, dealt with in an open plan customer service centre, and we were dealt with by a very new housing officer, so I kind of don't actually blame her that much really for this. She could have done better, but it wasn't her that was kind of driving this failure. And proceeded to tell the housing officer what the situation was, and the housing officer basically said, I need to go and make some inquiries to your GP before I'll accept the homeless application. And I was like, no, that's just not the way it works. You know, I think I even had a code of guidance with me at the time, and I was just trying to explain to her, look, that's just not how it works. You take the application, then you make the inquiries to the GP. And bearing in mind, this lady was, you know, there's multiple bits of information available for her. So she was on medication already. She'd been sectioned before. So long-standing mental health issues, plus this horrific kind of domestic abuse incident that happened a few weeks before. All of that stuff was happening. Now, if you know housing law, you'll know, even though this was before the Domestic Abuse Act kicked in 2021, it was about as plain as anything that this person might have been vulnerable. Now, that's the kind of threshold that we're at that stage. So kind of protested a bit, asked to speak to a manager, wasn't allowed to speak to a manager. And then we were basically sent away whilst they then went to make some inquiries. Bearing in mind that at this stage they still hadn't accepted the homeless application, which is again unlawful. So we went away, got a coffee or something, came back in the afternoon, and I'd emailed the kind of service director and the kind of I can't remember the title, but kind of the second in command of the big directorate of the council that housing was under. And basically said, here's some case law. This is obviously the case that this lady might be vulnerable, needs to be accommodated under Section 188. And when we got to go back to the housing office, again, Open Plan Customer Service Centre, the service manager, I don't know what his title was, but he was there with the housing officer again. And he literally started by basically reading out Section 214 of the Housing Act, which is essentially the right to prosecute people who are lying. And there was no evidence whatsoever that this lady was lying about any of this stuff, and it was all proved, very soon after this. But I don't know why they kind of took that line. I'm not quite sure what they thought they knew. There was another dodgy housing officer involved in all this, but they were kind of in the back office. That's another story. So, provided the information we had to provide, and the council issued a same-day non-priority decision, having not spoke to the GP, having not spoke to the hospital, having not spoke to the police, having not spoke to victim support. None of those inquiries were actually made, and as in they contacted the GP, didn't get anything back in that time scale, and so they issued a same-day non-priority decision. I basically, was about as deflated as I've ever been, really, because I was already, if you ever try whistleblowing, it's probably one of the worst things that certainly happened to me in my adult life. It's just horrible, turns your world upside down, and you're in this kind of insane sort of little bubble where you're like, you're reading what the law is, and you've got these very senior people at the council telling you that this is just not the law at all. So, as I say, very, very deflated, wasn't quite sure what to do. So basically had to regroup, made a plan, to contact the GP, get this evidence from the hospital, from the police and so on, which wasn't actually that difficult to do at all. And in terms of that stuff, a long story short, got housed shortly afterwards, maybe about 5 or 6 days afterwards or something like that. So kind of got it sorted out. But yeah, kind of had this complaint to then deal with. And to give you, again, I've kind of anonymised it, but you can kind of get a feel of how these complaints progress. So here's the complaint, the first stage complaint. Again, it's been anonymised and so on. It says Mitchborough, but this is kind of a case study I use for some of the training I do, so I kind of call Mitchborough, it's Bedford. Basically, and we're calling her Jane Smith here. So we've got the 6 points that I raised. So, kind of fairly straightforward. She went in on the 5th of June, it was, on the Monday, whatever it was, and, was told that there's nothing the council could do. We went back on the Tuesday, and I could talk all day about this, but I'm going to just home in on the 6th one here, because it just gives you an idea of the kind of battles you can have with the council about something so obvious. So this element of the complaint was: no officer made inquiries of Miss Smith's GP, hospital, victim support or police to obtain relevant information about Miss Smith's vulnerability before the 6th of June Section 184 notification was issued. That was the non-priority decision. And again, any sensible person would see that someone who is coming in, claiming that they've been subject to serious abuse, claiming they've been in hospital, claiming they've been, kind of had the police trying to press charges and so on, there is reason to believe that they might be vulnerable, and that would basically necessitate, if they're going to try and say that they're not in priority need, they would need to speak to those parties. Now, the complaint response was, and you kind of see how perverse this and stupid this can get, if I just find it for a second. Yeah, so this is the response. So and this is the 6th kind of subcategory here. So the 6th point I made, and the housing manager, whatever his title was, said: as you are aware from previous correspondence we have had, it is very clear from the relevant case law that it is up to local authorities to decide what inquiries are required in order to make any decision. There is no obligation to follow a prescribed format. The burden of inquiries are placed upon the local authority, but as the courts have said, this is not a CID level of inquiry and does not need every matter raised needs to be investigated. not sure how I'll go a bit further. The threshold of determining by the courts is that the inquiry should be appropriate to the facts known to that authority, or of which is ought to be reasonably have been aware. Now, in one sense, that's all true. You can't tell a council what inquiries to make. It is up to them to decide. But then we take it back to reality, where we've got a lady who's basically, nearly got killed a few weeks ago, police involved and so on. No rational, no reasonable housing officer or local authority could say that it's not necessary to speak to those, at least those 4 organisations, as I say, if they're going to try and say they're not in priority. Now, they don't have to make those inquiries if they're just going to accept the person is in priority. That's fine. There's no worries there. But to try and say that there is no reason to think that person might be vulnerable at the start, and then to issue a decision that the council satisfied that they're not vulnerable without having been to those different organisations is just it's just nuts. But this was a senior council officer with a straight face trying to defend that reluctance, or the refusal to make those inquiries. So, as I say, this is the kind of thing you can get caught up in if you're not careful. And certainly in the early days of me making complaints, I literally, my second stage complaint, I just unpicked everything that respondent had said and just kind of, just explained why it was nonsense. These days, I just wouldn't bother. I just basically go back to the point that not enough inquiries are made in the second stage complaint response. And so that was the first stage. And this first stage complaint response was issued or was written by that same manager that we saw on that Tuesday when we went in there. So, bearing in mind I'm essentially complaining about his conduct, he is the one who's then responding to me, which I don't know that that's definitely not okay, but it seems to be a little bit fishy, to be honest. And actually, just to give you an idea of the kind of the trouble you can get into, or kind of the flack you can get for doing this stuff, he'd actually sent me an email that Tuesday evening, and again I'll just read out a couple of bits of it. Because he basically just lectured me for a couple of sides of A4 or whatever, explaining, why was I insisting this lady made a homeless application? It was basically a waste of everyone's time. So kind of laid it on a little bit thick, and I hate this sort of stuff from local authorities. Back then I thought local authorities were a bit more important than they actually are. These days I'll just kind of shrug this stuff off. But at this point in my kind of career, I was at a real low ebb, so kind of I took it to heart. And it says, we enjoy close working relationships with the vast majority of charities and voluntary groups in Bedford, and we would like to be able to have the same relationship with you to work together to assist homeless people. However, the email below is an example of the adversarial approach that you've taken over recent months, which is hindering our ability to work collaboratively. Now, what I'd say about that is it hadn't just been for the last few months, it'd been for the last few years. We hadn't changed approach. We were just expecting the council to follow the law, so there was no kind of additional adversarial stuff that we'd done. And then he went on to say, I'm concerned that the welfare of this client, or of the client, is not always the priority in your dealings with the council, but that challenging and proving the council wrong are the motivation for your actions. This has given me cause for concern as to the suitability of Just Us to act as advocate for vulnerable people. Now, again, actually, it wouldn't matter if that was actually true. I would still be able to advocate for vulnerable people. There's no kind of way that the council could stop me doing that. But really, that's the kind of dig that a housing officer or a housing manager would have at someone. Bearing in mind this housing manager didn't really know me and certainly didn't understand the motivations for what I was doing. Had we wanted to just be a kind of spanner in the works, there was a million things we could have done to cause the council problems. We always took the least kind of invasive kind of way, or at least kind of the least disruptive way to kind of get this outcome. And there were many people we worked with who there was just kind of an absolute straightforward complaint to make, and they just didn't want us to do it because they just had enough. They just wanted to end it, or kind of end the process. Didn't want to keep having to bring it up in their lives. So there were plenty of kind of those open goals we could have gone for if we were that sort of people. But that's the kind of thing you can get. And I guess it's just worth kind of, again, just kind of going on to this idea of kind of gaslighting and kind of just really questioning your reality when this is going on. Because I'm thinking, well, do you know what? It's not ridiculous to insist that the council took that homeless application for anyone. This should be the route one for people to, if they're homeless, to get assistance. But then, this guy said the insistence on your part of making an application today has not advanced anything except for a formal decision to be made stating the reasons why the applicant is not in priority needs. Again, I don't know the internal motivations of this particular housing manager, but it's just nuts to say that, insisting, and that whole word of insisting, it's not something I should have to insist anyway. If someone goes to a council and asks for help with housing and tells them they might be homeless, there's no need to insist on it. The duty's already been triggered. But that's kind of what you're dealing with. And I guess I just wanted to raise this just to show you what happened with the stage 2 to kind of make it a bit more sense. So bearing in mind, stage 1 had not been upheld at all. So I'd taken it to stage 2. This is maybe a few months after. This lady's long been housed by this stage. And the stage 2 response, and stage 2 complaint, I may just reiterate what I said the first time, just a lot longer, because I was trying to deal with all this nonsense, which, as I say, was kind of actually not necessary. So the stage 2 response came from the service director or something, not sure what his title was again, and basically again, you can pause the screen and read it in more detail, but basically didn't uphold anything on that first day when I wasn't there. And to this day, you know, and when I hear of that housing officer that did that, you know, and kind of see her around, I'm a bit like, nah, do you know what, I just can't believe that genuinely this person didn't tell you that they're on medication, that they had mental health issues, that they've just been subject to domestic abuse, unless, I don't know, I just can't see how that would happen. But anyway, that's life. Some things just don't get upheld when they should be. But anyway, so that was the first day stuff. Nothing happened with it. There was no kind of admission of guilt. There was the director guy upheld the fact that I'd made the point that the records that were made on that day were not contemporaneous. They'd basically been written after the fact, and so he kind of accepted that. But then crucially, in this, going back to this whole big picture, we just submitted this report. The report was submitted just after this complaint was made, actually. And so whilst the MP and the mayor were looking into it, this case was all kind of rumbling along. And so, you know, a lot was riding on it, basically. If a case happened that was live that showed that the council was acting unlawfully, it was going to make a big difference to the outcome of that report. And that report most probably led to very significant improvements in the services I've kind of mentioned elsewhere. So if we actually looked at what the service director said, I've taken the view that the failure on our part resulted in Miss Smith having to secure her own accommodation with friends, and this must have had a financial as well as emotional consequence at a time when she was clearly very vulnerable. Now that's a huge admission, because the council basically had previously said she wasn't vulnerable. You know, that's essentially what the non-priority decision actually said, and yet this housing service director guy is saying that she was clearly very vulnerable. So again, from my point of view, I was like, the relief I felt when I read those words, because I thought I was going mad. You know, is it not obvious that she's vulnerable, having just been through all that stuff? But this kind of just really helped us out in terms of, first of all, getting her compensation. It was only a few days that she was left homeless, so again, she only gets £250. Maybe if I look back, I might have been able to ask some additional stuff there, but again, this was a lady who just wanted to kind of leave this all behind her and kind of move on, so didn't really want me to go to the LJO on it. But that's just kind of an example of how this kind of can transpire and what you're essentially up against. So just to reiterate what I said earlier in the video, the first stage complaint response will not only probably not uphold the complaint, but they'll probably say stuff which is just horrible, has a very negative impact on you, will make out that it's somehow your fault, make out that you're somehow acting unreasonably, often will kind of actually lie about stuff. I didn't go into the full detail of this. There were some outright lies. I'll give you one example, because the first housing options officer we've dealt with had specifically refused to take an application, and in the first stage complaint response, another bit of it said, we never refused to take an application. I'm like, I was there, you fucking idiots. So that's the kind of thing that can happen quite frequently, unfortunately. But you just need to get your head down, plough through it, get to that final stage, get to the ombudsman if you need to, and you're going to find that you have a much better outcome. So I'm hoping all this stuff has been really useful. There's a huge amount more I could say. If you want to put questions into the comments, and I might well make a separate video about the additional stuff, or I'll take the questions to the live stream on a Thursday night. So if you haven't seen that before, every Thursday evening we do a kind of live stream Q&A session where we just go through anonymised questions as best we can. But yeah, I think if nothing else, you know, if you're doing this for yourself, keep going, get your head down. And if you're a professional working in the sector, it's absolutely worth it. As I mentioned, elsewhere, this, if you look at the graph, look at the kind of the number of people in TA in Bedford, particularly single homeless people, who are the easiest people to gatekeep, as this person was, it's gone up by something like 4,000% on the back of these kinds of cases. So it's absolutely worth pursuing it, just ploughing through that resistance you get, just kind of, regrouping when you need to, acknowledging it's going to be absolutely horrific, and it absolutely was for me, but it was absolutely worth it as well. And I'll talk elsewhere maybe about the experience of whistleblowing, because I wouldn't recommend it. I don't regret doing it, but there might be other ways to kind of get a similar result without kind of having that catastrophic effect on your life. So yeah, as I say, I might do a separate video just to explain how all that works in reality, because there's a lot of professionals I work with around the country who just know this stuff's happening all the time, and don't feel like they've got agency to actually do something about it. But you know, as we prove with Just Us, it's absolutely possible for a small number of people, without anyone's permission, to go ahead and get massive systemic changes that are going to help a lot of people out. A lot of people that we never meet are going to be benefiting from the work we've done over the years. So yeah, hope that's all helpful, guys. Yeah, and if you're going through it right now, I feel for you, and just go easy on yourself, and kind of just keep plugging away, basically.